there is another bit of GADOS which I should show you, which may cast some light on the matter we were discussing earlier. So this is page 153 of the supplemental bundle. It's paragraph 43, which we've been looking at in detail, or at least looking at closely. So in the middle of that paragraph is the sentence that refers to what happens when an integrity check is failed, and I've made my submissions about what that clearly does not disclose. What that goes on to say is it talks about what happens if the integrity check is passed. It says the healthcare management software system 106 provides an indication of a verified database integrity in response to a past integrity test as represented by block 272. An exemplary indication of verified database integrity test is a message presented by one of the output devices. So that would presumably be something flashes on the screen saying everything's fine. Another exemplary indication of a verified database integrity test is the launching of the healthcare management software system, i.e. the fact that the system launches tells you the integrity test has been passed. Now, one could argue from that there was implied disclosure that if the integrity test is failed, then the system doesn't launch.
Okay.
You could argue that. Obviously, in that case, there'd be no features enabled. Nothing would launch. None of Figure 6 wouldn't be available. The healthcare system is the whole system, so nothing would be launched. So you could, out of that, argue that there's implied disclosure of everything being disabled. But I draw attention to that just to draw a distinction, because that reinforces the fact that what you can't draw out of this by way of disclosure, even implicit disclosure, is partial launch and partial disablement. The other point I should mention, I don't know where this is going, but because well, you'll see what I mean by that.
You should see the look of the people behind you.
They know where it's going. Because I wasn't expecting it to be said that Dr. Palerme's evidence in 9.2 and 9.3 in the second report which I showed you either described something within the claim or that referred to disclosure of the document. And I wasn't expecting that because, in particular, because obviously the controllers considered that and didn't consider it relevant. We're just checking his reports, and in particular his instructions, to see whether that casts any further light on exactly what questions he's considering in 9.2 and 9.3. Obviously, you have my submission that it's clear from the context, just clear from the words of paragraph 43, that he's not talking about what's disclosed in the anticipation sense.
So your point is you may need to put in a bit more if you find anything of Mr. Palerme's evidence to show the context of the statements.
Yes, or a nil return. And what I mean by that is we're just checking to see whether he was actually asked to consider disclosure of the anticipation sense, because unless an expert is told, when we say disclosure, we mean clear and unambiguous, and the distinction between that and obviousness, then an expert can't be expected to draw that fine line.
Okay.
So if he wasn't if he wasn't asked to consider that, then that would obviously be highly material to the questions that I was debating with your lordship, and we'll get back to you. I don't want to put in anything. I don't want to say anything without having done a proper due diligence on this.
Okay. Mr. Warren.
I'm grateful. My Lord, in writing, I started with a discussion of the controller's role and what I can, and I suppose to some extent what I can't, reasonably assist the court with today. I'm proposing to take that as read, particularly with a view to finishing today. And equally, I wasn't proposing to trouble you at this stage in relation to the delay in producing the trial judgment, partly because my learned friend doesn't rely on it very much. It does become relevant in the context of ground 3 on 223, particularly on my submissions, and so I will address it only briefly when I do, but I'll do it if it pleases. So I'm proposing to jump straight in on EP 627.
Yes.
On that, before going to the grounds themselves, there is a short point of principle on them both, on which the judge relied and which I don't understand Abbott specifically to criticise, but which I think bears emphasis because it's central to the approach to the construction and to the reasoning why these grounds, I will say, are not well founded. The principle expressed generally is this. One must carefully draw a distinction between text in a patent which delimits the scope of the invention and text in that patent which exempts the invention. It is generally impermissible to read limitations into the claim and to limit the monopoly arising from embodiments that are described in the specification as examples. Those embodiments are just examples and can't be used to limit the invention more broadly. That principle was expressed neatly by my Lord Mr Justice Floyd, as he was then, in Nokia and IPCOM. We can just take this from the judgment in this case. It's at paragraph 154, which is page 101 of the core bundle, and the quote of the relevant part is at the bottom. All I will be saying is that that's a correct statement of the law and it's terribly important today.
So this is, yes, bottom, so this is paragraph 154. The judge
Yes, the judge has quoted from Nokia and IPCOM.
Yes.
Yes.
The patent use general language but described by reference to a specific embodiment, not normally legitimate to write limitations into a claim corresponding to the detail. Yes.
Yes, so one can't look at the claim language, which is very broad, and then say, but look at this example in the specification, which isn't that broad, that must be what the claim means. It's just an example of something that falls within the claim, it doesn't limit the claim. That was an important part of the judge's approach to construction, and a significant part of the reason he rejected Abbott's approach. And on this patent particularly, I will say it's a good reason why my lords should reject Abbott's approach on this appeal. So paragraph 143, the judge set out the claim in integers and addressed its proper construction from 144 onwards. Perhaps it would be convenient to turn that up, but I'm certainly not proposing to go through this part of the judgment line by line. So 144 to 148, the judge set out the core of each party's position as to the construction, and there's no suggestion that he did so unfairly. And finally, at 149, the judge points out that Abbott addressed two of the terms used in Claim 1 in particular, namely the predetermined routine or PDR and the nature of the second indication, and he set out the submissions on each in the following three paragraphs. And those indeed, I highlight that because those are the parts of the claim that now go to grounds in the opposite order, 1B and 1A respectively, on this appeal. The judge then set out his analysis at 153, but the key point when he did so, which is why I've drawn it out before we go to the two grounds, two sub-grounds I should say, is the point at 153, amplified by the quotation you've just seen at 154. If you could just read 153 to yourselves, my lords, please. So the judge is clear that this principle applies equally to and bit on both parties, and that he considered both parties had sought to some degree to put limits on the scope of the claim, but the claim itself didn't, and he points to what he called the obvious generality of the wording used in Claim 1, which we'll obviously examine in due course. After the quote from Nokia, at 155, the judge then begins, with that principle in mind, I turn to consider the interpretation of various terms.
Yep.
And then once again at 171, once he's been through all of the various elements, he goes back to the Nokia point once again. So it's clear that the judge was alive to what I'll just call the Nokia principle, and that it formed an important consideration in his interpretation of the claim. That approach was entirely proper in law and principle and forms a large part in my submission of the answer to these grounds of appeal. So to take the two sub-grounds themselves, first ground 1A, this one my lords will recall, is the one where the objection is, it said the judge wrongly held that the first and second indications of the STS guide, prior art, corresponded to these integers of the claim. The judge was wrong to treat them as relating to the same predefined alarm condition. I'm going to go through this in a little bit of detail, which isn't meant to make it sound like it's going to take all day. It's not. but I'm going to go through it in detail, but I'll give you the short version now. The short version is this. My learned friend has treated the two notifications as if they must be notifications of the predefined alarm condition. So he says because the two notifications are not the same, the predefined alarm condition cannot be the same. But the notifications, as we will see, are not in the claim notifications of the predefined alarm condition. They are associated with the predefined alarm condition. One can have two different notifications relating to the same predefined alarm condition. We'll see, to take the example I used in writing, if the predefined alarm condition, once you have detected that the device has been installed, because it's not already going, the 3 days isn't counting down in the box, when you've detected it's been installed and that therefore expiry is at 12:34 today, or 3 days' time, a notification that you've got 30 minutes left and a notification that you've got no minutes left might be different notifications, but they are associated with the same predefined alarm condition that expiry is at 12:34. My learned friend just says, well, look, the two notifications are different, therefore they can't be for the same predefined alarm condition. But that reads a limitation in there because the notifications must only be associated with it. So it's at 2:04 in the judgment, my lords, just to take it a little slower, that the judge found it was appropriate to rely upon impending sensor expiry as that predetermined alarm condition. The fact that in the STS guide it's disclosed that the sensor will expire at the time 72 hours after installation. Now that's of course the step where the detection arises, because it's got to detect that it's been installed. That's why one doesn't just detect the time in an absolute sense, it's the time from installation. So it is a detected condition.
So just to make sure I've understood what you're saying, you can imagine the little gizmo in your hand, and it'll be switched on, but it may not have a sensor connected to it. And then you connect a 3-day sensor to it.
Yes, there's a calibration period for the sensor, as I understand it.
Okay. And then the point you're making is it was on anyway before the sensor started. But then you fit it with a sensor, and then the 3 days starts from when the calibration is.
Or the calibration has been done. Any of these things could be the thing that's detected. But one detects the condition that this is now a sensor that will expire at 12:34 today.
Right. Yeah.
So that has been detected. There is no provision in the claim that the detection must be at the same time as any of the notifications. It simply has to have been detected. My learned friend placed a lot of emphasis on detected, but the reason it is detected is it's not just a property of the universe. It's not just detecting what the time is. It's detecting when is this thing going to expire, which is a function of what's done with the device. Then the predefined alarm condition is 12:34 on Wednesday, and you get two different notifications, one that says 30 minutes left and one that says no minutes left. So the center of it is the notification isn't a notification of the predefined alarm condition. The language of the claim is it's just got to be associated with it. So the two notifications can differ.
So your point, part of your point is the fact that two notifications differ doesn't mean that they are not both associated with the same detected predefined alarm condition.
Exactly so. That's, in essence, that's the beginning and the end of my argument on ground 1A.
Okay.
Sorry, what's the detected predefined alarm condition on your argument?
Is that it's going to expire at 12:34 today, because that is the time 72 hours after the completion of the calibration.
So that's expressed as something that's going to happen.
Yeah, the impending
It's not
expiry,
a-
as the judge put it.
How does that work for the last of it's expired?
Because it's still associated with the predefined alarm condition, which is that it's going to expire at 12:34. It's because of that broadening language in the claim, associated with. It's not got to deliver a statement of the predefined alarm condition. It's just a notification associated with it. So the device gets
So
installed.
is it saying, sorry, is it then saying, is the second notification on that view really saying 30 minutes ago we told you that it was going to expire in 30 minutes? That seems quite a, to me at least, seems rather a surprising way of looking at it. Because that, you seem to be saying that the predefined alarm condition is that it's going to expire in 30 minutes.
Well, it's the, let's call it the absolute. So it's the, I keep using 1234 just because it's a, so when the thing has been installed and calibrated, that starts a 72-hour clock. 72 hours is not from the date that the thing's manufactured or something. It doesn't start in the box. The 72-hour period is 72 hours of detection. So this whole process gets started once the thing has been engaged in that way and calibrated. So it's detected that there is now an expiry time associated with this sensor, which there was not in the box. Once it's detected,
it doesn't do anything at that stage. It doesn't say
it doesn't need to. No.
72 hours is now starting to run. It tells you.
But there's no. There's
The
nothing to
two
do.
bits that you're relying on are the 30 minutes and the end, as I understand
The
it,
bits the judge relied on, yes.
which the judge relied on. So the first of them is saying in 30 minutes it will expire.
And the other one's saying
second is
it's around
it has
12:34.
expired. And you're
Yeah.
saying that's the same.
I'm saying they're both associated with the same thing. So once the thing has been fully set up and is in use on the person's arm or abdomen or however it's been set up, it says, right, now, unlike when it was in the box, this has an expiry time. It is now 72 hours, is at 12:34 on Wednesday. It then gives two notifications. The first notification says 12:34 on Wednesday is in 30 minutes time. The second one says 12:34 on Wednesday is now. Those are both notifications that are associated with the condition that expiry is at 12:34 on Wednesday. It's the associated with wording that my learned friend is effectively reading down. It's not having to display what the predefined alarm condition is in order to be a notification. It's just got to be associated with it. Saying it's in 30 minutes time and it's now are both associated with the same condition that this is now a sensor that expires at 12:34 on Wednesday. As I also explained in writing, if the output display were configured to convey the same information as it does, but just formatted differently, perhaps instead of saying 30 minutes left, it said expiry time 12:34, time now 12:04, then it would be even harder for my learned friend to say that the alarm condition changed, then the notifications would have the same information in. And I repeat the submission I made in writing that it would be slightly strange if such a trivial change of format as that would bring you within or without the scope of the invention when the same information is being essentially conveyed. The judge dealt with this argument briefly at 214 in the judgment, which is on bundle page 111. If my lords could just remind yourselves of that paragraph, please. So as you'll see, I embrace that approach. And let's just look, in fact, at the integers of the claim. If we turn those up on bundle page 96. We're looking at integers 1.3 and 1.4. So it's a first indication associated with the detected predefined.
96, did you say?
Sorry, sorry, have I got the wrong page? I've got a different version. So it's internal page 36. It's paragraph 142 of the judgment. Let's just the setting out of the claim in integers. I'm sorry if I had the wrong page number. Integers 1.3 and 1.4. So the first of those, outputting to a user interface of the receiver unit a first indication associated with the detected predefined alarm condition, and again in 1.4 the same language, a second indication associated with the detected predefined alarm condition. So it doesn't require that they convey the exact same information about the same predefined alarm condition. It just requires that they both be associated with the same one. So that really is the beginning and end of the argument on this. The short point is that the claim is formulated in very broad language, and we'll see the effect of that perhaps even more acutely when it comes to ground 1b. But the judge wasn't in error to take the approach that sensor expiry at some time t, defined by when the device starts to be used, was the detected predetermined alarm condition, predefined alarm condition, excuse me, with which both the 30-minute and 0-minute notifications in the STS guide were associated. So that ground shouldn't, in my submission, succeed for those reasons. There is one small piece of housekeeping on this one. I alerted my learned friend before we began today. Paragraph 68 of my skeleton, I would respectfully ask my lords just to put a line through that. I have made a simple mistake. I'll explain why. I related part of the judge's judgment that I had, when I first read it, seen as him recording the submissions of the parties with a little bit of his commentary. I think actually on looking at it again, I think he is just recording the submissions of the parties, so it wouldn't be fair for me to rely on that as part of his reasoning. I don't think, as my learned friend said to me this morning, I don't think that makes any difference to anything, but I wanted to be proper and front up to my mistake and ask to withdraw that paragraph. So that's ground 1A. 1B. Here, the point in dispute is what is in the disclosure of the STS guide that can be read onto the predetermined routine of integer 1.1 of the claim. So we need again to start with the words of the claim, because in my submission, the point that's fatal to Abbott's ground of appeal here is the very breadth of that term in the context of the patent and its claim. The patent itself makes that extraordinary breadth clear. So the starting point, not the end, but the starting point as ever is the words themselves. And so without more, predetermined routine isn't a term which on its face has some narrow or precise meaning. So next we look at the words in the context of the claim they're in, and in particular integer 1.1, which is executing on a receiver unit a predetermined routine associated with an operation of an analyte monitoring device. So again, on the face of the words, this looks very broad. And then once again, we have the words associated with an operation. It doesn't even have to be part of an operation, just somehow associated with one. And an operation must mean potentially any operation of an analyte monitoring device. As my learned friend has highlighted in his skeleton at paragraph 36, the claim does in other integers introduce two express features that do limit the PDR. The first is that integer 1.9 requires that it must include one or more processes that interface with the user interface of the receiver unit. And the second is that it requires that the PDR be executed without interruption during the outputting of the first notification. So that's it for the claim language on its face. But now we must look to the specification.
Is there a third possible limitation in 1.5, which is that it can be completed?
Yes, I suppose that's right.
So in other words, it contemplates it being time limited.
Or functionally limited in some. I'm not saying necessarily time limited, but it's something that's capable of being meaningfully completed. Yes, that might be right. I'm not aware that my learned friend places any reliance on that for the purposes of his appeal, but I don't think I quibble with that, my lord. Right. But anyway, if we go to the specification itself, at paragraph 80, which is in the supplemental bundle behind tab 1 at page 12 of the bundle. Could I ask you just to remind yourself, you were taken to paragraphs 77 to 81 by my learned friend this morning. If you could just briefly remind yourselves of paragraph 80. So the first point to make here is that this paragraph, like all of that series of paragraphs my learned friend took you to this morning, are exemplifying. They're embodiments. So paragraph 77 talks about figure 10. Paragraph 78 begins, that is, in one embodiment. 79, more specifically, about that one. 80, which my lords have just read, within the scope of the present invention, i.e. not defining the limits of it. And then 81, in this manner, in one aspect of the present invention. So the first point about this is, the context is we're exemplifying the invention, not delimiting it. And the second is that the definition my lords have just read includes expressly broadening language several times over. So the predetermined routine may include one or more of, for example, or any other processes, including but not limited to. I'm not reading all the bits in between because my lords have just read them. So it's clear in my submission the patentee intended the scope of PDRs within the invention to be very broad. Anything comprising a process that interfaces with the user interface or with performing a fingerstick blood test will do it. And to be clear, the language of 80 is such that even this paragraph doesn't define an exhaustive account of the invention. These are just examples of what might be a relevant PDR, as indeed my learned friend describes in his skeleton at 24a. He says that 80 gives examples, and he's right. So the judge rightly at 212 in his judgment described the scope of predetermined routine in the context of the claimed invention as being deliberately broad. He's plainly right about that. And a definition of PDR that is so very permissive is in my submission an unhappy starting point for a ground of appeal that the judge's approach to assessing it, or looking for one in the prior art, was too permissive. So that's it for the relevant term of the claim that we're considering. Now back to the STS guide, and we're of course concerned with essentially the same parts of the disclosure there that we were under ground 1A. And perhaps we can go back to the judge's comparison of the disclosure of the STS guide with the integers of the claim. You were taken to this morning, and it starts at 202 in the judge's judgment, paragraph 202, which I believe is on page 109 in the bundle. The relevant integer, as we've seen, is the first one, integer 1.1, which is dealt with at 203. The judge is clear. His finding is the PDR Dexcom focused on, he's using the one that Dexcom focused on for its anticipation attack, which is the routine which counts down to the expiry of the 3-day sensor session. The judge then deals with Abbott's arguments against this, which are substantially the same at trial as are now presented on appeal, perfectly properly, that's not meant to sound barbed, at 212. My lords could perhaps just read paragraph 212 briefly, please. So my lords will see that the two arguments essentially relate to the two respective integers that I referred to earlier that expressly limit the PTR, that is integers 1.6 and 1.9. And Abbott's two central points on this ground, likewise on appeal, are in essence allegations that the judge failed to take proper account of the effect of those two features, and I say that's misconceived. As to integer 1.6, that it not be interrupted by a first indication, Abbott says that a countdown to sensor expiry in the STS guide cannot be the PDR since it's not capable of being interrupted. First, we don't see there to be any basis for saying this is necessarily correct of the STS guide disclosure. It's surely possible that the sensor expiry routine is one that could be interrupted by a display of a first notification in some way. It doesn't make a disclosure contrary to that we can see. Secondly, though, there's anyway no requirement in the claim that the predetermined routine be one that is somehow interruptible in the first place. Nor is there any definition.
Sorry, how do you mean that the sensor expiry, what's the sensor expiry routine? Is that just a passing of time?
Countdown. Yeah, it's the countdown.
So that's just time passing.
Yes, and
So how can that be interrupted by the first notification?
well, it's because the sensor has got to be, it's got to be keeping the time. We're not just talking about the flow of time in some epistemological sense. The sensor has got to keep time and keep time correctly.
But
So in the same way a clock is operating when it's on.
it'd be a very odd way of looking at it if when there was a notification, the clock stopped. Which seems to be what would be meant by the interruption of what you call the routine, which is just the passage of time.
I accept it would be unusual, but there's nothing in here which makes that impossible. It doesn't say it stops counting for a second and then it makes itself up because it knows the notification is a second long.
Sorry, it is impossible. You can't interrupt the passage of time.
But this is the point, is the machine isn't taking care of the passage of time. The machine, one doesn't say that a clock isn't doing anything because time is moving anyway. The clock is telling the time, and the clock here, this routine, has got to keep accurate time. It's not, we're not just talking about time in some generalized epistemological sense, as I say, that just happens to flow. The machine has got to keep time. And so it's capable of being, in terms of it could know that the giving of a notification takes 1 second. And so actually, it stops measuring the time, but it adds 1 second when it's finished doing the notification, for example. There is nothing in here that makes that impossible. It's a very unusual way for something to work, but it's not true that this is impossible, which is the submission that's made by my learned friend. That's not to say what the actual time out in the world is changes, but the time told by the clock may stop moving for the duration of the giving of the notification, and if it knows how long it displays a notification for, then it can just add it on when it gets to the end.
I'm afraid I'm still having difficulty, not the only thing I'm having difficulty with in this field, but the claim with which we're concerned is about a machine which performs a number of functions and then has as one of its functions alerting of an alarm, alerts or alarms. And I had understood that the essence of the claim was that alerting or alarming doesn't interfere with the other processes that the machine is trying to carry out.
I think that's a fair paraphrase of how one could expect the claim to work.
I'm glad that's fair, because it doesn't seem to me to be a characterization of what you're talking about, which is simply that time passes. That's one of the functions. Well, it is not a function of the machine that time passes, it just does. And we're dealing with a machine which has to be, or a sensor which has to be removed after 3 days.
My lord, I think with respect one needs to take the focus off time passing in an abstract sense and put it onto the time that is being told by the machine. On my lord's version of well time passes, a clock doesn't do anything. A clock doesn't need any mechanism on that view of the world. It must tell the time by producing, whether it be a mechanical, whatever way it goes about counting the time, it produces an account of the time. So it is here. If one knew that the display of the notification took a second, then the mechanism that goes on to count time could stop for a second, display the notification, and then just add 1 second to the time at the end, because it knows that's how long it spends producing a notification. There is a difference between the passage of time and the telling of time by a machine. Otherwise, a clock doesn't do anything. But anyway, perhaps the easier point, the second one that I have just made, is that there's anyway no requirement in the claim that the reason why the predetermined routine is not interrupted, that the predetermined routine not be interrupted, but it was interruptible, simply has not to be interrupted. If that's because it couldn't be interrupted, that's fine. It still satisfies the feature of not being interrupted. My own friend tried to give an example this morning about him interrupting his own submissions and said that that was nonsensical. Well, the output of that then is that his submissions weren't interrupted. So it is here. The claim doesn't have any express requirement that it be somehow interruptible. All that's required is that it's not interrupted. If that's because it couldn't be, then it still meets the feature of the claim. So there's no language in there that has the effect of, notwithstanding that the nature of the predetermined routine is such that it could have been interrupted, that limiting feature isn't there. And there's no justification for reading it into the claim, given the patentee's apparently deliberate choices to cast the scope of PDR for the claim so very widely. Then finally, the final point that Abbott takes in its skeleton on this subground is that it says the 3-day sensor session period counter cannot be the PDR of claim 1 because it doesn't interface with the user interface. The judge's answer at 212 was simply, it does via the 4 alerts. Those 4 alerts are the ones he listed at paragraph 200, which are disclosed in the STS guide.
It's a bit odd, isn't it, that the way the claim is constructed, that it does require that the predetermined routine has to interface with the user interface, and the argument that it does is the very indications which are the things which the claim is about, which are interrupting or not interrupting the routine. That doesn't feel like what the person reading this would have thought you were getting at when you read that. Is that fair? You say the words at the end and that's that, I get that.
Well, it's not just the words in a literalist sense, it's the words as aided by the dictionary that is the patent specification telling us what they mean.
Indeed. But one also interprets claims as you do interpret any language purposively, trying to understand what the inventor's purpose was. And what strikes me is that one might say, and this is I think what Mr Abrams is saying, is that the inventor's purpose was contemplating 2 different things. One was the predetermined routine, which does have to interface with the user interface in some way, and the other is something else, which then, that's why he says there is this at least possibility of interruption. I take your point, you can say, well, the claim doesn't say the words that you have to be capable of being interrupted, but the concept of interruption seems to contemplate something else happening, which is different from...
It certainly contemplates it, and that would certainly be within the claim. But if what was intended was the narrower claim, then they shouldn't have written the claim or the specification in the terms that they did, is the simple answer. It's not a linguistic argument based purely on the language of the claim without context. I've taken you to the bit of the specification that defines it, and it defines it extremely broadly. So my lord might have given a very good reason why the patentee shouldn't have drafted the claim as they have, but that's not a good reason to pretend that they haven't.
Okay.
So that's it on the first patent, 627. If it pleases, 223, I'm afraid, as the judge says less about each of these. grounds our job gets a little harder as we go through. So I'm going to have to spend a little more time on these because, to be perfectly frank, we've got a little less to go on in terms of reasoning. That's not to say, of course, that the judge is wrong just because he's expressed himself more economically, but it does mean that I need to spend a bit more time, I fear. The third, I think, is probably the one that will require a bit more context in terms of law and principle, so I'll probably reserve most time to that, particularly on my view of supporting the judge's conclusion. So first is the scope of safety critical application, and in particular of safety critical in Claim 1. So paragraph 1 of this patent, you can see this in Supplemental Bundle tab 2, I think it's page 32. So paragraph 1 says, safety critical systems are systems whose failures or malfunctions may result in significantly detrimental consequences such as, so not limited to, death or injury to persons, severe damage or loss to equipment or to environment. And then it goes on. Now, as I understand it, we agree, my learned friend Skeleton at 50 and 51, that this text is the appropriate source of the definition of safety critical, which must be read into what is a safety critical application. So the starting point again is that the patentee has given and deliberately chosen to give a definition that is extremely broad. It includes those applications whose failure or malfunction may, but don't necessarily, lead to some very serious consequences, such as death to persons, but also those applications whose failure or malfunction may, but need not necessarily, lead to much less grave outcomes, such as loss of equipment or damage to the environment. Loss to environment and so on is, as we said in writing, a little bit difficult to understand fully, but I don't think that matters very much. The point remains, on any view, this is very broadly defined. Even the given examples of consequences of failure or malfunction, which are expressly not the limits of this definition, it says they're not, are ones covering a very, very broad spectrum of potential adverse events. Next we go to paragraph 3, which begins, medical systems are an example of safety critical systems that require a certain level of confidence that the system will operate and continue to operate properly. Medical systems may detrimentally affect a user's health and well-being if not operating properly or not known to be operating properly. So again, this is plain that safety critical systems are not limited to medical ones. They're just merely an example of a subset of them. And even this subset is itself a very broad subset, because it's clear that there are applications that, to quote from paragraph 3, require a certain level of confidence the system will operate and continue to operate properly, and may detrimentally affect a user's health and well-being if not operating properly, or even just not known to be. So taking this description on its face, the subset of safety critical systems here includes medical systems whose not operating properly, or even who might be operating properly but we're not sure, would be a serious enough consequence to make a particular system safety critical, because either the non-proper working or the not being sure that it is properly working may affect a patient's well-being and his or her health. So again, taking the patentee at its word, this is a term with an extremely broad scope. The judge dealt with its construction at 342 to 346 of the judgment. And at 342, he started by noting Dexcom submissions that 1 and 3 of the specification that we've just seen are the basis for understanding what is a safety critical application as used in Claim 1. That led him to the finding, which he makes at 343 and confirms at 345, which is the one that Abbott says in its skeleton at 51 it doesn't quibble with as far as it goes. That finding is that a safety critical application is a software application whose failure or malfunction may result in significantly detrimental consequences such as death or injury to persons, severe damage or loss to equipment or to environment. And you've just seen where that language came from. But having said that they agree with that as far as it goes, in reality, as the rest of that paragraph of their skeleton makes clear, and my learned friend made clear this morning, Abbott argues for a rather narrower scope of consequences that can make an application a safety critical one. They say now that a safety critical application should only be one whose malfunction or failure would directly affect the patient. And as I noted in writing, this essentially repeats the argument that they made at trial, which the judge rejected at 344 to 345. That's page 140 of the core bundle. And my lords, could you perhaps just remind yourself of those two paragraphs? My short submission is that the judge was right. We've seen how the patent defines what's safety critical. It does so in clear express words, arranged so as to be very broad in scope indeed. Abbott's construction instead reads limitations into the claim that the patentee not only didn't put there, but in circumstances where the patentee instead was at pains to define the term very, very broadly indeed. And a further point is that this narrowing that Abbott contends for is inconsistent with paragraph 1 in another respect. When I read out to you some of the words from paragraph 1, I was careful to emphasise that it said that a safety critical application system, rather, in that paragraph, is one whose failure or malfunction may result in significantly detrimental consequences. Now, Abbott seeks to say that it must be one that necessarily results in detrimental consequences and that those consequences must be direct. Now, a failure or malfunction directly causing some adverse effect is quite different from one which may lead to some such effect. And there's no basis in this specification or the claim for reading in Abbott's limitation. Nor does the patent say that the harm caused must be to a patient. Quite the opposite. As you've seen, paragraph 1 expressly envisages, and by way of non-limiting example, that the consequence of a safety critical system's malfunction could merely be loss of equipment or loss to the environment. Now, there is the point that to some degree, whether a given application is safety critical in fact will always depend on the particular factual context at the time surrounding its use. An example we gave in writing was if the patient is simultaneously, by a sort of belt and braces approach, simultaneously being monitored using one or more other devices to monitor the same condition, then one could immediately say that this application in question may no longer be safety critical in that particular factual circumstance. That indeed is perhaps why the wording in paragraph 1 is expanded to any application whose malfunction may lead to one of the wide scope of deleterious consequences. So that one doesn't have to prove each time that the facts of use for a particular alleged infringement were such that it was in fact safety critical at the time. The point is that the general functioning of the application could have safety critical consequences should it malfunction or fail, and the patent is clear that the scope of things it considers safety critical consequences for that purpose is extremely broad. So as far as the construction of Claim 1 goes, the judge was right not to read Abbott's extra limitations into the claim. Having dealt with the claim in that way, the anticipation in my submission becomes all but inevitable, because in truth, without the additional direct link that Abbott contends for as a limitation to be read into the claim, Guidos reads straight onto it. The judge set out a short summary of the relevant disclosure of Guidos at 422 to 428, including in those last three paragraphs an account of the major points in dispute. And then, if my lords could turn it up, he dealt with this particular issue about safety critical application at 429 to 434, which is pages 157 to 8 of the core bundle. At 429, the judge records that Abbott's expert had two reasons for saying Guidos didn't disclose an SCA, and Abbott's ground 1 is focused on the second of those reasons. 432 to 433 give the judge's answer to Abbott's submission. The relevant safety critical application is the Guidos database of patient physiological information itself. At paragraph 53 of their skeleton, Abbott contend that the system of Guidos would always be used alongside other resources to make treatment decisions. I mean, that sounds plausible enough. But as the judge noted at 432 sub 2, Guidos doesn't impose any limitation on how or where its system will be used. And as we noted in writing, even in its skeleton on appeal and indeed this morning, Abbott hasn't put forward any basis in Guidos's disclosure for saying that its use is disclosed as being limited to use alongside other systems. But perhaps even more to the point, Abbott here again is seeking to read additional narrowing features into the claim that aren't there. There's no suggestion either in the claim itself nor in the agreed definition arising from paragraphs 1 and 3 that we've seen, that a safety critical application is only safety critical if it would always be used alone. And at 433 of the judgment, the judge was clear that even on the assumption that Guidos is used for nothing other than a retrospective review of a patient's blood glucose data sitting in the doctor's surgery, even a malfunction in that system, as my Lord Justice Burst put to my learned friend this morning, even a malfunction in that system could itself result in harm falling squarely within the paragraph 1 definition if, for example, the example the judge gives, it led to a poorly informed adjustment of the patient's treatment. Put shortly, as the Chancellor put it this morning to my learned friend, in Guidos, the integrity check is there because clinically it matters. So in summary, on ground 1, the wording of the patent is such that we're concerned with any application whose malfunction may lead to any one or more of a very, very broad set of consequences that are said to be adverse. Even if it were true that in most ordinary use of the Guidos system, its malfunction may lead to such a deleterious consequence, but only if relied on by itself, there is nothing in the disclosure of Guidos that suggests that it doesn't fulfill this claim feature. Doubling up observations, as I've said, with another monitor could stop almost any system from being safety critical on its own on the facts. But this claim plainly isn't concerned with that, and paragraph 1 of the specification makes that clear, and I've explained there's probably a good reason for that. Guidos's disclosure isn't so limited either. So ground 1 fails because the definition of safety critical is so extremely broad, and the judge didn't make any error when he found that Guidos disclosed such a safety critical application. There was an exchange this morning about what might be non-safety critical features. In a sense, I say that's not a question that the judge had to answer in the sense of making particular ones, but examples might be, and these are my examples, not the judge's, altering the text size in the display, or changing whether the data are produced in, for example, a bar chart or a scatter plot. They would be non-safety critical. They're clearly functions of the application presenting the patient data. So there was an exchange this morning about what might be examples, and my learned friend drew a convenient blank. So those are just some examples that one might posit. Ground 2, I'll take this one as quickly as I can, because my submissions are essentially as set out in my skeleton, but there is a little more to add. There's no reason not to be entirely candid. I find this one quite difficult, and I could see this morning there was some difficulty in finding relevant. I will do my best to produce where it is that I think the judge had in mind for the taking of an image and so on, but we'll get there when we get there, if it pleases. So the starting point is, as the judge found, and my learned friend accepts now, there is no reason why the same check can't fulfill more than one purpose and be both a check of function and of installation. So the claim feature can be satisfied as long as the check or checks allow it to be determined whether the application is installed properly in some relevant respect and functioning properly in some relevant respect. And I add those two caveats in for reasons that will become clear when I say in some relevant respect. The other point to make before we get to the detail on this submission is it's important to remember in my submission, Guidos was run as a squeeze. It was a squeeze on infringement. By that, what I mean is, Dexcom said, we don't infringe this patent, but if you manage to swell your patent so much that you say we do, then you run into this piece of prior art. That's important and relevant because, of course, the patentee wants the claim to be as broad as possible when it comes to running an infringement case, as it did, and then wants it to be as skinny as possible when it comes to avoiding the prior art, as it did. Such a case was run, and we'll see that in a moment, particularly when it comes to the definition of what counts as a functional check. My learned friends are slightly hoisted by their own petard on that because it's the very submission that they made that the judge accepted that then meant the judge was able to rely on when he came to consider the validity. That's an important point just about the shape of the case that in my respectful submission my lords must bear in mind when looking at validity. Of course, they don't have any infringement case now, but they're still stuck with the case they ran and which the judge accepted below in terms of what the claim means. So, the disclosure of Guidos. The judge considered anticipation of the installation check and functional check features respectively at 435 to 438 and 439 to 444. That starts on bundle page 158 of the judgment at Core Tab 6. I don't propose to go through that, but that's for my Lord's note. Now at 43 to 44 of Guidos, there is disclosed the database integrity check. My Lords have been shown that this morning, but if it pleases, it would assist just to turn it up again It's in the supplemental bundle at tab 4, page 153. Again, for my Lord's notes, this text corresponds with figures 4 and 5, principally, of the disclosure of Guidos, and those are referred to expressly in those paragraphs. We don't need to turn those up for now. We might need to look at them, well, we'll need to look at the figures in a moment, but for now I just seek to help to orient my Lords with that. So the check described there considers the database's data integrity, and if the test is failed, there is a notification. One can see that from the end of 43 itself. But if we go back to the start of 43, to check the integrity of the patient database 104, the Healthcare Management Software System 106 loads the integrity information 108 and database integrity information 111 as represented by blocks 264 and 266. So those blocks 264 and 266 are in figure 4. But in order to see what just to give you the context of what this integrity information and the database integrity information are, those can be seen in figure 2, which is back on bundle page 141. Database integrity information 111, you can see on the right hand side, and the integrity information 108 down at the bottom. And the best assistance I can find as to the nature of those is in paragraph 31. I'm sorry that there's so much jumping about to do, but
Can you just hold on a second?
of course.
Thank you.
Of course. So paragraph 31, if it pleases, explains what this integrity information is. Integrity information 108 is information contained separate from the patient database, which provides a check of the data in the patient database to ensure that the physiological information 110 or information based on the physiological information 110 is presented correctly. I wanted to go through that first, just to show you some context of what I think the judge was probably reaching for when we get to his finding. So the judge considered that this integrity check, the one in paragraph 43, read on to claim 1. To do that, he followed the oral evidence of Dr. Palern, Abbott's expert, in relation to the installation check feature. And in my submission, he can't be criticised for relying on that. The judge's paragraph 437, says the installation check is satisfied by checking an image of a single component of the safety critical application, including a database file. So my learned friend tried to suggest that this had to be a check of the integrity of the entirety of the database. Here it just says a database file is the finding that the judge made. And you've just seen what the database integrity information is in paragraph 31. It's probably the best we get. And that's not limited to something that validates the entire integrity of the entirety of the database either. It's some information which sits separately from the database itself, which tells you that it appears to have its integrity. That last sentence is, of course, a paraphrase. I've just shown you the paragraph itself. So that amounts to checking the database by looking at something that is not the database itself. So there is a basis for this finding that the judge made in 4.3, where he accepted Dr. Palern's evidence, but I think that's the best trace of it I can find in the express disclosure of the prior art. but I freely accept this is, because the reason's very compressed here, and of course I wasn't at the trial either, that's the best I've been able to do. I fully accept it's not straightforward, but I think that there is, my primary submission is the judge can't be criticised for appraising Dr. Pelham's evidence and relying on it. But just to go behind it a little to satisfy ourselves, I do think one can see that paragraph 31 disclosure as being at least consistent with the finding that the judge made. So that's for the installation check. And since it's now accepted, the same check can satisfy both requirements, as long as the installation and function can both be determined. The question now becomes just whether the same integrity check can also determine whether the system is functioning properly. And again, here we start from the claim itself, which is extremely broad. There is no basis for any suggestion, and I don't think Abbott are, in this respect, suggesting, but if they are, I say it's not right, that such a functional check, as they put it, must verify that every last aspect of the functionality of the safety critical application is working 100% correctly. As I've already alluded to, part of Abbott's difficulty here arose because it was not just arguing that the patent was valid, but that it was infringed by Dexcom's acts. As so often, this created a squeeze, because Abbott needed the claim narrow enough to skirt the prior art, but broad enough to capture Dexcom. Now, in the context of infringement, as we'll see, the judge had to consider what might satisfy the functionality check in the claim. It relied upon an indirect check of functionality, a check of something which, if it weren't working, would mean the application couldn't work properly. Not a check which, if it produced a positive result, necessarily meant the application was, in all respects, working correctly. The argument ran, Abbott's argument ran, that the time check includes a determination of whether, in this respect at least, the relevant system was functioning properly, because the system couldn't function properly if it lost track of the time. If we look at that in the judgment, paragraphs 394 to 407, bundle pages 151 to 153 are relevant bits. If one looks first at, if I ask my lords to read first 398 and then 407, I've given you the full set of paragraphs, but I think if we just read those two now, that's probably suffices. So plainly the judge found, as Abbott itself had contended, that a check on the functionality could be limited to just checking a particular aspect that would be fatal to the functionality if it weren't working, such as the maintenance of valid time. At 401 there, the judge showed that the patentee's chosen language in the claim is broad and that there's no limit placed on it by the description, only, again, examples. So an indirect check on functionality of this sort could properly, he accepted, satisfy this functional check aspect of the claim. So what can be a functional check is extremely broad, because that's the argument that Abbott made and succeeded on. So back with that to the disclosure now of Guidos. The claim doesn't suddenly get to shrink when we come to think about the prior art. It means the same thing whether we're considering infringement or validity. As the judge notes at paragraph 440 on page 159 of the bundle, in fact, perhaps my lords could just read that paragraph, probably quicker. 440 and particularly Roman 2.
Thank you.
So the GuideOS system will not function properly if the database has lost its integrity. That's sub 2. Now the judge notes that if the database integrity check fails, the ability of the healthcare management system accurately to record, store and display the patient data, including, for example, glucose values, will potentially have been impaired. So that aspect of the system's function appears not to be working correctly, and the integrity check has flushed that out. The integrity check, therefore, serves as a functional check, the broad version of a functional check that Abbott successfully contended for, as well. So the judge was right to find that the integrity check of GuideOS does satisfy the installation check and functional checks that the claim requires. And in my submission, that should be the end of ground 2. So if it pleases, I was proposing to move now to ground 3, which is the final one, which will require a bit more of a run-up for 2 reasons. On my case, the very short version of my answer to ground 3 is, the judge determined this based on the evidence. He was entitled to have regard to the evidence to do so, because it's an implicit disclosure argument. And this court shouldn't go behind his appraisal of the evidence he saw and heard. That's the very short version. Because that is how I think a well-advised respondent would present their case, that does potentially engage the issue of delay. My learned friend says the delay doesn't really matter very much, and on his case, I see why he says that. On his case, that's right, because these are all construction points, and he says this is just a matter of the words, and they're not there, and that's the end of it. But because in my submission, the judge was right to rely on the evidence, and this court shouldn't go behind what he drew from it, the question of the appropriate degree of deference does arise on the case I think a well-advised respondent would run.
Wouldn't the well-advised respondent be wanting to say the judge did understand the evidence?
Well, of course, but
So it isn't
they want to say
the well-advised respondent was well on.
but they can certainly come here and say it's right, but in any event, you shouldn't be going behind it, my lords. That's a very common position for a respondent on an appeal when there's a multifactorial evaluation. I'm not suggesting they would be resorting to saying, well, don't look. Not at all. But it would be a perfectly proper point for them to run to say, this is the judge's appraisal of the evidence, he saw these experts, you never will. There's an awful lot of law about deference to appraisal of evidence in the context of a multifactorial assessment or an evaluative decision. And so because I think that's a point that they would run, and so it's a point that I try and assist you with, I have to engage with whether that deference has changed because the judge took a long time to write the judgment, whether the appropriate level of deference is reduced.
But the appellant isn't relying on that. Sorry, I don't want to waste time on this, but the appellant didn't make anything of it, so...
You'd be making a defensive point.
Yeah.
Yes,
You'd be
but
saying, well, the judge was right anyway.
Nothing to defend yourself against.
So, I don't know, but...
Well, it's certainly if this is a point of if you think this is a point of evaluation for the judge, then my learned friend is absolutely right. Then it's a point of evaluation, and then the delay is highly material. Of course, I've already submitted whether it's evaluation or not. He's wrong on any test. But if the test is an evaluative determination test, then delay is obviously material. I mean, and there's not much more to say about it than what my learned friend has said about it. I'm not going to make a big deal about it.
Right.
But he's
Why
right.
don't you show us the authorities very quickly?
I'm not going to be here until, I'm not proposing to trespass on your time for ages. And also I run this point because I'm here on behalf of the public rather than a private respondent. And so I did want to be over-inclusive and try and help you more. If it's not helping you more, then very well. I'll do it as quickly as I can. There are two principles here that I need to help you with, one of which there is some authority for, and the other of which I don't think there is anything that will help us very much. The first is the point of patent law, which is what is the role of evidence on this question about implicit disclosure. On that, we absolutely do engage with each other. The second is I am recognising in the capacity that I have and the way that I'm supposed to be assisting the court, that then gives rise to, my case being he was right to rely on some evidence, it gives rise to a question of, well, what degree of, how do we treat an evaluation of the evidence by the trial judge in these circumstances? As to that, I'll make a very short submission, but I'm not going to be able to assist you with lots of authorities. So my learned friend's case, essentially, is that GUIDOS doesn't actually disclose expressly the disabling features in response to a failed integrity check. Paragraph 43, my learned friend says, discloses an error message being provided by an output device, but without any clear express reference to removal of functionality. That could just be a warning that could be ignored or dismissed, he says. And as a reading of the express disclosure, it's difficult to disagree with that, and it may be my failing, but I don't see a point that a respondent could raise to gainsay that directly. But the judge's approach didn't, and rightly didn't, I say, begin and end with the express disclosure. In law, the prior arts disclosure also properly includes what's implicitly disclosed to the notional skilled addressee. And that to the skilled addressee bit is very important. What he or she would glean from the disclosure, notwithstanding that it's not said in terms in the document, is a matter on which the judge will be informed by the expert evidence, as I will show you. Difficult to see how else they could determine such a thing, but I will show you the authorities that make clear that it's appropriate to be informed by the evidence for that. Indeed, it's part of the role of the expert to educate the judge about the background knowledge and context that the skilled person brings to his or her reading of GUIDOS, informed by the relevant common general knowledge in the field. That's an absolutely necessary part of the inquiry, and as I said in my skeleton, it's that background knowledge and understanding of the technical field that makes the notional skilled addressee skilled. And those in turn are a sort of factual finding. They're not factual findings in the direct real-world sense. They're not factual findings about things that actually happened, but they're factual findings arising from the evidence about what was the body of knowledge at the time that a skilled addressee in this field would have. They relate to a particular species of fact because they're not real. They're about the thoughts and reasoning of a fictitious creature, but they are nevertheless factual findings, based on the judge's appraisal of the evidence he heard from 3 experts, perhaps materially 2 on this question, as to what knowledge the skilled addressee would bring to bear on their reading of GUIDOS. And so that's why I will have to deal briefly with the role of the judge's delay. And just to be clear, first of all, I can't and I don't shrink from the fact that the judge took an awful long time to produce this judgment. I'm not going to suggest that that delay is acceptable. The trial finished on the 13th of December 2022, and the judgment is dated a short way into 2024. I've been clear in writing that that's most regrettable, and the controller will not seek to defend that sort of time on its terms. But that doesn't really, insofar as that goes, help dispose of the appeal. Having taken too long to write his judgment, can't make a correct interpretation made by the judge an incorrect one. The documents say what they say, and that hasn't changed. So where the analysis has been focused just on the documents, my lords can engage with them on substantially the same basis as the judge and just decide whether or not he approached them correctly. But as Lord Justice Arnold expressly alluded to when he granted permission in this appeal, the judge's delay can affect the degree of deference to his appraisal of the evidence. And this is there's only really this ground where that has any role. At 29 to 30 of my skeleton,
Why does it affect the level of difference? Is it because after so long, there's no assumption that the judge is on top of the nuances of hearing the evidence?
Yes, I think, as I said, my lord, I'm not going to be able to burden you with lots of extra authority on this point, but that's what I understand the explanation would be, is to say, well, one of the reasons that we defer to trial judges generally in their appraisal of the evidence is that they were there, they saw all the nuances, they saw how the person behaved, as they were able to appreciate the evidence.
Their sense may be blunted by delay.
Yes, if they're effectively working up those impressions again from transcripts a long time after the fact, then their position, the trial judge in this sort of situation, are in a position that's much similar to the position my lord finds himself in, which is there's a lot of paperwork and you've got to try and create the best sense one can of what happened at the trial. And so the comparative advantage that the judge enjoys is lessened the less reliable his recollection of his impressions at the time.
Forgive me for taking up another half minute, but if there is evidence which, if accepted, which is potentially acceptable to the trial judge, and if accepted, provides an acceptable basis for his findings or their findings, does it differ much from the approach of a normal appellate court to findings of fact?
My position will be no, and that's what I propose to converge on, which is to say, even if the judge, well, not even if, even though the judge has taken a long time and is clearly in some part, and we'll never know which bits, producing his judgment very considerably after the trial, he nevertheless still can be taken, and I'll explain why, to enjoy a material advantage over my lords when it comes to forming an impression of that evidence, such that the appellate principle should still apply. That's where I will get to. But I have to front up to the fact that I was not able to find an awful lot of authority to help me with that. I think one has to do it from principle in the way that my lord proposes, which is to say, what is the difference between the trial judge and us, and how is it attenuated in circumstances like this?
I think there's been a recent decision on this of this court. There was Lady Justice Falk.
So
She has summarised, because there is a certain amount of authority on it, and I think within the last month or so, 6 weeks, Lady Justice Falk gave a judgment dealing with this point, I think.
I'm not aware that I've seen that one.
Unfortunately, I don't know the name of it.
No, well, I'm not aware that I've seen that decision. I've certainly seen decisions which say delay, and I don't need to argue this out because I understand it to be accepted, that delay of itself isn't a ground of appeal. And that's why I made the submission I did a moment ago, that something can't be made wrong that was otherwise right, simply because the judge wrote it a long way after the trial. But as to a precise test or something like that, I've not seen anything, and I'm afraid, my lord, if that appears in Lady Justice Falk's judgment, I don't think I've seen that. I apologise, I've not found that.
All right. Well, I'm sure we'll have a wee look. We'll certainly have a wee look after this hearing. But
Well, and I will of course be happy to do the same, and if I find it, I will pass it on to my lords as soon as I'm able to.
thank you.
So at 29 to 30 of my skeleton, I explained that an anticipation attack requires 2 elements: disclosure and enablement. There's no controversy about that. And in this case, we're concerned with the former, the disclosure of the prior art. And as Lord Justice Arnold explained in the recent appeal in relation to the Moderna COVID vaccine patent, the test is a strict one of either clear and unambiguous disclosure in the prior document or clear and unmistakable directions to do something which in fact falls within the claim. That much is uncontroversial. But as I explained a moment ago, the question of what that notional skilled person would glean from the document is, as my Lord Justice Miles put to my learned friend this morning, the question of what that notional skill is informed, by the expert evidence about the context with which they're reading. And that includes the implicit disclosure. If we take my skeleton actually at paragraph 35, where I referred to Mr Justice Jacob, as he then was, in the Herx-Celanese case, and I've quoted the relevant part underneath it, which is why it's probably easiest to take it from my skeleton. Reading the highlighted part, it must be right to read the prior art with the eyes of the skilled man, so if he would find a teaching implicit, it is indeed taught. The prior art document is novelty destroying if it explicitly teaches something within the claim, or, as a practical matter, that is what the skilled man would see it is teaching him. Now I emphasise this carefully because on the other hand, in Moderna, at paragraph 58, Lord Justice Arnold said, and it's the bit that my learned friend took you to this morning, under paragraph 19 of my skeleton, where he says novelty is a binary question which depends on the application of the correct legal standard to the prior art. But the next few paragraphs of my skeleton amplify the next bit of what Lord Justice Arnold says in this paragraph that I've quoted, namely, the interpretation of the prior art is a question of law once the court has been properly instructed by the expert evidence as to the common general knowledge with which the skilled person reads the document, and hence the technical considerations which bear upon its interpretation. So as was put to my learned friend this morning, it is a technical matter to say what are the things that the skilled person would glean from this that aren't written there in black and white. Lord Justice Arnold's paragraph, just to be complete, ends, it follows that there is a right answer to any question of novelty. It's not a matter of evaluation taking into account multiple factors and applying an imprecise standard like obviousness. Now, on the face of it, that last sentence or two might be thought to be saying there's no role at all for any judicial deference when on appeal from a finding of anticipation, but I say that's not right. The prior sentences of that paragraph make clear Lord Justice Arnold was talking about the binary novelty question that's addressed after the disclosure, that is the whole disclosure including what is implicitly disclosed to the skilled addressee, has been determined. The point on this ground of appeal is about the stage before, the stage of determining what that disclosure, including the implicit disclosure, is. It's centred on the part of the analysis that's properly informed by an evaluation of the expert evidence. Notwithstanding the delay in producing the judgment, there is no basis for approaching matters on the basis here that he did nothing, produced no notes or anything like that, until very shortly before hand down of the judgment. It's perfectly reasonable to assume, in the judge's favour, that he was diligent in taking notes at trial, recording the impressions that he formed at the trial, and he then had the benefit of full transcripts to read alongside those notes, to refresh and prompt his memory alongside any notes he made. All of that still confers a material advantage on the judge as compared with all of those of us, my lords and myself, who are arriving at this matter purely on appeal. And that being so, in my submission, unless the appellant were able to demonstrate that the finding is simply obviously wrong, for example, because it in fact is not something that either expert said, it is appropriate for this court to let the judge's assessment of the evidence stand. And so that goes to the answer that I gave to my Lord Justice Stuart-Smith a moment ago. So with that rather long run-up on the two interlinked points of principle, and taking them as briefly as I can, given the point that my Lord very rightly makes that this is a defensive point against a point that isn't live on the appeal. I can engage with the ground of appeal itself very briefly indeed. The judge was persuaded by the expert evidence, and particularly by Dr. Sturbu, Dexcom's expert, in relation to the implicit disclosure that the skilled person would glean from reading paragraph 43 of GUIDOS. Dr. Sturbu said that where that paragraph states that an error message may be presented in the event of a failed database integrity check, the skilled addressee, and this is now a quote, would understand that this includes disabling safety critical database related functions when the database integrity check fails. Now my learned friend seeks to characterise that evidence, and he showed you the paragraphs from Dr. Sturbu's report in the supplemental bundle as being evidence going to a sort of obviousness, what it's obvious to do. With respect, I don't accept that account. If one turns up tab 5 in the supplemental bundle, and it was paragraphs 246 and 247 on page 162. This is the bit that is the source of the evidence that the judge accepted. Paragraph 246 begins, paragraph 43 of GUIDOS states that, and then the next sentence says, the skilled person would understand that this includes disabling database related functions. I say the sensible understanding of that is that the this is what GUIDOS is saying, what GUIDOS is teaching. It's not saying, once you've read this, you might have a bit of a think and you might come up with this, obviously. He's saying that this disclosure I've just set out includes these things from the perspective of the skilled addressee through whose eyes all of this evidence is given. Similarly, in 247, and this is the one about enabling non-safety critical features, the skilled person would understand from GUIDOS paragraph 43. Again, he's not saying, once they've read paragraph 43, they put it to one side, and if they have a think, they will obviously think of doing this. He's saying what they understand from that paragraph. That's the compendious consideration of the express and implicit disclosure of the paragraph, what it teaches, as we often put it in these cases. So the judge ultimately accepted this aspect of Dr. Sturbu's evidence. He also relied on Dr. Palom's evidence in the paragraph before, which I haven't referred to in my skeleton, my learned friend rightly says, but that's because the judge made a finding about it and it wasn't challenged by my learned friends. And as my lords have seen this morning, one could read those parts of Dr. Palom's evidence entirely consistently with the finding the judge has made there. So there's no suggestion this is a false representation of something that Dr. Sturbu said, nor is it something that's really dependent on some nuance in the room that one had to have a pristine memory of how the trial went in order to recall it properly. Nor is it really right, in my submission, to suggest that this is evidence about an obviousness-like consideration. This is what do you get from paragraph 43? That's the disclosure express plus implicit, I say. So really, Abbott's position is reduced to just saying, well, the judge shouldn't have been persuaded by this, for the reasons my learned friend sought to amplify this morning. And that's the sort of point that shouldn't succeed on appeal for the reasons I've set out. The judge was entitled to this appraisal of the evidence, particularly since it largely has come from the written evidence. And once the judge has reached that finding on the evidence about GUIDOS's disclosure, including its implicit disclosure, which it's appropriate to look to the evidence for, the ground essentially falls away. Abbott finally seeks to make a point at 62 in their skeleton that Dr. Sturby's evidence doesn't quite go far enough, because he says when you look at 246 of the first report, it says the skilled addressee would understand 43 of GUIDOS includes disabling the safety critical functions. He didn't say what happened to the non-safety critical ones. In my submission, that strains his evidence too much. It's a clear implication of this part of the evidence that it's only only some safety critical functions that would be disabled. That's the sensible and reasonable way to understand this part of the evidence in context, especially in the light of what 247 says. At the very least, the judge was entitled to understand Dr. Sturby's evidence that way and to accept it. And having done so, the assessment for the judge inevitably came out in favour of anticipation.
He did actually say in 247,
Yeah.
the next paragraph, that
Yes.
certain features were not.
Yes, that's why I say particularly in light of what he says at 247. Quite so,
Yeah.
I embrace that fully.
But, so one can't go as far as to say, well, he didn't say it. It's just the judge didn't refer to it, as far as one can tell.
Well, he didn't, I mean,
He didn't expressly.
does the judge expressly need to refer to paragraphs in the evidence for every finding he makes? The answer to that must be no. So there it is. At the very minimum, the judge was entirely entitled to understand this evidence that way. I just don't think there's any mileage in the suggestion that this is all about something that's obviousness-like, given the wording of 246 and 247. The final point that my learned friend makes is he says it was wrong for the judge, even if he correctly understood Dr. Sturby's evidence, to take it on board, because that necessarily amounted to abdicating the judge's responsibility to construe the claim for himself. In my submission, there's nothing to that criticism. Just because the judge has accepted Dr. Sturby's evidence and found a construction that's informed by it, doesn't mean that the judge didn't do any thinking for himself about construction. Entirely proper for him to be informed by the evidence as to what the implicit disclosure is, as we've seen. And if that gives a complete answer, once he's made that finding, to a question of construction, then that's that. It doesn't mean that he hasn't done the analysis just because a clear answer is found on the basis of the evidence he properly had regard to. And indeed, the entire structure and approach of the judgment makes clear that the judge knew fully well he had to interpret the claim. And as Moderna makes plain in this court, it was appropriate, even necessary, one might say, for the judge to be informed by the expert evidence when approaching that. My Lord, so unless I can assist you further, that concludes His Majesty's Controller General's submissions on ground 3.
Thank you, Mr. Barron. Yes.
I can be brief, my lords. So I'll just go through the 5 grounds. On ground, so we're back on EP 627, ground 1A. And this is the 2 conditions, 1 condition, 2 notifications point. Just standing back, obviously, it's not, my learned friend's reading of this claim is not a purposive reading. It's quite clear, and he didn't seem to disagree, that the purpose of the patent and the invention of 627 is, as I've said, to alert the user without interrupting, but then re-alert them. And the STS guide functionality has got nothing to do with that. The biggest flaw with his submission on ground 1A was that he did not really acknowledge the importance of the word detected in claim 1. Claim 1 makes it clear that it's a detected condition, and it says the detected condition all the way through. So it's absolutely clear that a condition is detected, and the 2 notifications relate to that same detected condition, i.e. the one detection. And his reading, as I think he acknowledges, requires 2 separate detections. I say as he acknowledges. In fact, there's a bit of prevarication from my learned friend, which I should just draw out. As I understood his submissions this afternoon, he was saying that the detection occurs when the sensor is first put in, and that then detects that in 3 days' time at 12:34, the sensor will expire. That was my understanding of the way he was putting it. That is not how his written submissions are written. I showed you paragraph 58 of his skeleton argument, page 43 of the bundle, which is much closer to being accurate. So in 58, the condition that is detected at 30 minutes out is that you are 30 minutes out. And then although he doesn't say so in 58b, it must be the case that at 12:34 there is another detection that it's now expired, and that leads to the notification. So it can't be the case that it simply detects it's being put in and then the notifications just appear magically. There must, as he acknowledges in his paragraph 50a, there must be some sort of software trigger that occurs 30 minutes out. That is the detection of the condition. And there must be another software trigger at 58b that is the detection of the condition. And of course, to the extent that we're speculating as to how it works, that means there can't be anticipation. It's only if it must work in a way which is within the claim that there can possibly be anticipation. But as it happens, I agree with his 58a. 30 minutes out, there's a condition that's detected. But that must mean that there is another detection at 12:34, a detection that a detection that the full 72 hours has now elapsed. My Lord, my Lords, on ground B, my Lord, the Chancellor put it to my learned friends in a way which I hesitate to paraphrase because it was so clear, but my Lord's point was that the claim is clearly talking about two separate things. That is to say, the PDR, which interfaces with the user interface, and the alarms, which do not, the first one doesn't disrupt the PDR, and the second one, alarm from the same detected condition that comes after the PDR is completed. And as I say, I hesitate to paraphrase because my Lord put it so clearly, but that's exactly our position. And that is completely the correct approach as a matter of purposive construction. The skilled person reading this understands what it's saying because it's so clearly explained what it's trying to do. And what is going on in the STS guide is simply nothing of that sort. My Lord, moving on to 223. Ground 1, safety critical. My learned friend referred to damage to equipment or the environment, and I can dispose of that quite quickly. Integer 1.3 of the claim states that the safety critical application is a medically related application. And then paragraph 3 of the patent, of the 223 patent, explains that medically related applications are applications where damage is to the health of the patient. Let me get the exact words just so that I'm not misquoting. Medical systems are examples of safety critical systems, ... may detrimentally affect a user's health and well-being if not operating properly or not known to be operating properly. So we can leave aside equipment or the environment because the claim is limited to medically related safety critical applications. That doesn't answer the crucial question, of course, which is how directly it must need to lead to such detrimental effect. And as I say, I accept the point that my Lord put to me originally, that you could, with almost any application, I say, you can posit a chain of events which lead from malfunction to a detrimental effect on health. But it is clear from reading the patent purposively, that it is talking about safety critical applications which are really safety critical in the sense that they can lead directly to harm. My learned friend rose to my challenge of trying to identify what is a non-safety critical feature, and he identified altering the text size and a bar chart and a setting relating to a bar chart or scatter plot. And we make two responses. First of all, on the judge's approach to safety critical, those would be safety critical. I mean, altering text size, if that malfunctions, such as the text size is too small that the user can't tell the difference between a 6 or an 8, then one can see how, if they then misinterpret that and then take action and so on and so forth, that would lead to detriment to health on his approach. So on the judge's approach, which my learned friend is supporting, those would still be safety critical features. The even better point, from my point of view, is of course that neither of those are disclosed in GADOS, or indeed in any of the, or mentioned in any of the evidence as to what GADOS discloses. So it is a matter that gives me great encouragement that he wasn't able to give you an example of a safety critical feature. Excuse me, he wasn't able to give you an example of a non-safety critical feature disclosed in GADOS. So it certainly can't be said that GADOS discloses such a thing and discloses that such a thing is enabled even when an integrity check is failed. On ground 2 of 223, I don't think there's anything to add to what I said in opening, which was simply they don't check installation or functioning properly. They check that they check the accuracy of the data in the sense of that the units are correct, and that's a different thing. My lords, ground 3, I have 6 submissions to make. My learned friend was right to highlight the issue of delay because he was saying that this was a matter of evidence for the judge. We say that the judge was obviously wrong, just looking at the document. He's obviously wrong to say that selective enablement was disclosed. And the fact that that decision came after a period of delay just explains that and ought to make your lordships even more comfortable in overturning him than you would be just on the basis of the plain words in black and white on the page. As my lord pointed out to my learned friend, he didn't really grapple with paragraph 247 of STRBU and the requirement for enablement of non-safety critical features, and that we suggest is likely to be a symptom of delay and gives your lordship even more reason to form your own view to the extent that you wouldn't be forming your own view in any event.
Was the witness actually challenged on any of that evidence?
No, because it's a matter of disclosure. I mean, consistent with the submission I'm making now, I did not challenging him on, no, it doesn't say that, it says this, because that's a matter for the judge. I explored in great detail within the common general knowledge and who the skilled person was. But when it comes to what does paragraph 43 say on its face, that wasn't a matter for him. He not having suggested that there are any technical terms in it. My second submission is on the topic of implicit disclosure. And implicit disclosure cannot include...
I mean, just a second, Mr. Abrams. You say, well, you're not waiving privilege, obviously, reasons why you didn't cross-examine the witness on this. I'm just looking at 247, 246 and 247 again. If you just bear with me. Look at the previous page in the evidence, which is 161 of the bundle. The heading is Comparison of GADOS and the Claims of EP223. The witness says at 242, I've set out my comparison of the claims in detail below, as against GADOS in detail below. In my view, GADOS discloses all of the integers for claims 1 and so on. Then he goes through the integers of claim 1. On the next page, he finds 246 and 247. So a reasonable reader would understand that to be under the rubric of this is why I say GADOS discloses all the integers of claim 1. Then if you then read over to the next page, he finishes going through the claims, and then there's a heading that says obviousness over GADOS. So what the witness expert's report is the way it's structured is that this is about disclosure of GADOS.
Yes.
Okay.
So I say, when I say following Moderna, I mean that Moderna obviously postdates this trial. But the point being made in Moderna very clearly was not by Lord Justice Arnold. It's not a new point. It's a standard point that the question of disclosure of the document, both the patent and the prior art, is a matter for the court once it's been properly equipped with the mantle of the skilled person. It's not for experts to parse the language of the document and not for counsel to cross-examine that parsing of the document with them. We've included in the authorities bundle the relevant section from Terrell, which includes all the lots of quotations from authorities, rather than overburdening the authorities bundle with statements from various judges saying it's not for experts to parse the language of the prior art, nor is it that a matter for cross-examination. Obviously, it's sometimes necessary for the witness to set out what he understands, which integers he's seeing and which integers he's not seeing, so that the discussion about obviousness or other questions arising at trial can happen. So sometimes it is necessary for a witness to do this, but it's not appropriate to have a debate with a witness about the meaning of plain English words. Obviously, if he'd have said in paragraph 2246, error message has a particular special meaning in the medical field, then obviously that would be a matter for cross-examination. But it wouldn't have been appropriate to have fenced with him over the meaning of a sentence that's perfectly understandable to a judge.
Right.
On implicit disclosure, our submission is that cannot include other possible ways of implementing, cannot include possible ways of implementing the prior art if other ways of implementing the prior art are left open. So complete shutdown of the healthcare system, or non-opening of a healthcare system, appears to be contemplated by the end of paragraph 43, because it says one possibility is if the check is passed, then the healthcare system launches. So it's contemplating that if the healthcare check is failed, the system doesn't launch at all. Given that that's contemplating, one can't say it's implicit that a whole range of different possibilities are all implicitly disclosed. There might or might not be things which would occur to the skilled person, but it can't be the case that you can implicitly disclose a whole range of possibilities. And indeed, if you look at, you see this if you look at paragraph 246 of Dr. Sturbu. So I think your Lordship's got that on page 162 of the supplemental bundle. The first sentence simply quotes paragraph 43. Then he says, the skilled person would understand that this includes disabling database-related functions. Now, he gives no reasoning at all as to why the skilled person would understand that includes disabling the database-related functions. But what's absolutely clear is that he's saying that this is one of the possibilities. He's not saying, clearly this is telling me that you must disable database-related functions when the database integrity checks. He's saying includes, i.e. this is one possibility. That's why we say that word together, the whole sentence, the words would understand, this includes. Although prefaced by paragraph 242, as my Lord has pointed out, is really the language of what would occur to a skilled person, and not what is clearly and unambiguously disclosed. And likewise, there's no reasoning in paragraph 247 why these features are to be regarded as non-safety critical features, nor why it is implicit that they would be enabled if the database integrity check fails. And one can make the same points about the evidence of Dr. Pelern, which I handed up in paragraph 9.2 and 9.3. I was right just after the short adjournment when I said that Dr. Pelern's instructions were relevant. Because GAIDOS was being run, I assume because GAIDOS is being run as an obviousness case, I'm not waiving privilege or telling you this. Dr. Pelern was not instructed in accordance with the Synthon, what I call the Synthon test, clear and unambiguous disclosure. His instructions were simply, and I'm going to read them out to you, so that I don't get this wrong.
What are you reading out?
I'm reading out his instructions from his first report as to how he approached GAIDOS, and we'll email this to you. The point I'm making is that he wasn't instructed about what I call the Synthon test, how the importance of clear and unambiguous disclosure and the difference between disclosure and what would occur to a skilled person reading the document, which is not disclosure as we lawyers call it. He said, after reading 223, I was asked to comment on the differences between what is claimed in 1, 7 and 9 of 223 and what is disclosed in GAIDOS, and whether the additional features would be obvious. So he was asked to comment on the difference between claim 1 and what is disclosed in GAIDOS, but he was not given the instruction which is essential for someone embarking on this question, which is you've got to distinguish between what is clear and unambiguous on the one hand and what would occur to a reader reading it on the other hand, which, while meat and drink to people who've done this for years, is not something that a normal human being would readily appreciate without being instructed. So what it would be wrong in my submission to treat any of Dr. Pelern's evidence, in particular paragraphs 9.2 and 9.3, as directed to the question of disclosure in the Synthon test that we use for the purpose of anticipation.
There's one more point on that, Mr. Abrams.
Yes.
Paragraph 9.3 is in direct response to paragraph 247 of Dr. Stuart-Smith, which is, we've already seen, in a section concerning disclosure.
Yes. Yes, but that still doesn't detract from the fact that Dr. Stuart-Smith.
And this is your witness.
Yes, indeed, but that doesn't take away from the fact that Dr. Stuart-Smith wasn't instructed.
You're not talking about Dr. Stuart-Smith, you're talking
Sorry,
about
Dr. Pelern. Excuse me, forgive me. That was a slip of the tongue by me.
Okay.
The point that you make about 9.3 doesn't detract from my point that Dr. Pelern was not instructed as to what disclosure for the purpose of anticipation means, and therefore it would be wrong to read his evidence in 9.2 and 9.3 as being directed to that test, as opposed to what I've suggested, which is that it's directed to a practical implementation of GAIDOS relevant to the debate about obviousness. Despite all of everything I've said, actually this does come down to a simple point. The simple and best point is that paragraph 43 just simply does not disclose either limb of selective enablement. It doesn't disclose disablement of anything if there's a failed check. It doesn't disclose a non-safety critical feature, nor is there any other disclosure of a non-safety critical feature elsewhere in GAIDOS. And 43 does not disclose enabling of a safety critical feature. And it's important not to lose sight of the fact that ultimately this is about the meaning of those words. One might even say that the judge was at a disadvantage because he heard the trial and he heard a great deal of argument in cross-examination and in opening submissions at least about what a skilled person would do with GAIDOS and how they would proceed. And we suggest that he muddled up those questions, such as one might get from 9.2 and 9.3, with the question which he was answering, attempting to answer in his judgment, which is are both limbs of selective enablement clearly and unambiguously disclosed in paragraph 43? Because if he'd have focused on that question, there is literally only one possible answer. If the test were Wensbury unreasonableness, then his conclusion that it's disclosed in paragraph 43 would be Wensbury unreasonable. It's just not there. And perhaps that's all I ever should have said on ground 3, that those are my submissions.
Very good. Thank you very much.
My lords, simply, yes indeed. I apologise for not having seen the judgment of Lady Justice Park. I was just going to, I'm not going to make submissions about it, I don't think that's fair on my learned friend, but the case is Phones for You and EE and 7 other. The intervention of the Competition and Markets Authority. The neutral citation is 2025 EWCA Civ 869. And the relevant paragraph appears to be, insofar as I've been able to look very quickly, 218. The principles are expressed at a very general level, so I'm not sure they take actually the discussion any further forward than I had suggested. It gives me an authority for the one submission I made, which is that unless there is something materially wrong with the way that the judge has recalled the evidence, and it's clear that that includes if he has materially omitted some important piece of evidence, not just misrecollected a piece, then that can be something that one would inquire into. Whether that's actually any different from the position on an ordinary review, I'm not actually sure, but that may be a problem for another day. Does the court wish a short submission on the effect of this or not?
No, thank you, Mr. Barron, but thank you for drawing it to our attention. That's very
I'm
good.
grateful, my lord. Nothing further from me, my lord.
Very good. Well, we'll rise in a moment, and you will not be surprised to know that we'll reserve our judgment. We will receive it in the usual way, which means it will be subject to the embargo. The embargo is serious. I know you know that, and it will be distributed to the people you've given us on the distribution list. So do make sure the distribution list is up to date. Do remember that the judgment may not be disseminated outside that distribution list. Thank you very much.
All rise if able.